This is a level 3 aggravated battery case. It's also a self-defense case, so that will be our argument at trial. There's also some additional charges, including battery by means of a deadly weapon and pointing a firearm. But at the end of the day, the case boils down to self-defense. So what are the issues? Again, this is a self-defense case, and when we're talking about self-defense cases, one is the level of force that's used. When we're talking about a self-defense case, you can't go beyond the force that was used. Here, this is a deadly force case. So my client used deadly force in his self-defense. So one of the issues is, was there deadly force used against him? Another issue is, did he use too much force? For example, the case we're working on is a case where a gun was fired. Is one shot too many? Is 100 shots too many? So is how much force was used, the length of time the force was used, is that an issue? And then just kind of the story. There's obviously different sides to the story, and so there's going to be an alleged victim that says one thing happened and is going to suggest then deadly force wasn't needed, and then there's going to be other victims that say other things happened and suggest that deadly force is needed. So what is the strategy for voir dire? The strategy for voir dire is we really want to make sure that we get obviously the right jurors. Kind of the initial strategy is going to be to remove any jurors that just shouldn't sit on this case. Whether that is a juror that they have committed, domestic batteries in the past, they would be a terrible juror for this. Maybe they're jurors that simply think that because my client has been charged with a crime, he's guilty no matter what. Those jurors we don't want. But then the strategy to kind of pick, okay, out of the other jurors that maybe they're going to be a good juror, maybe not. We want to find the jurors that really seem to understand self-defense. They understand the difference between self-defense being objectively reasonable and subjectively reasonable, and they also understand that self-defense is not something that is not always this bright line yes or no, right? There's a lot of gray area in self-defense. So we want to find the people that are willing to listen to the evidence, and the people that are going to just look at everything and understand why my client acted the way he acted and why he had to act the way he acted. And so we'll be asking questions to kind of determine what is their understanding of self-defense, what they expect self-defense to be, and things like that.
Hi, so right now I am researching some case law on self-defense for a jury trial we have coming up on Monday. Our client was charged with aggravated battery after he defended himself against another person, and where ultimately the other person was shot. So right now I'm looking at some case law to determine the subjective versus objective definition of self-defense. I'm also going through the client's depositions and the depositions from all the witnesses, along with the body cam from the officers that arrived on scene.
So we wrapped up the first day of our jury trial today. This is a self-defense trial. It's going to go into multiple days. We think we're likely going to be able to conclude it on day 2, but part of that will be up to the jury. First day, kind of the morning, is spent doing what we call voir dire. That's jury selection. The jury selection process for a major felony case, so any case that is a level 5 felony or higher, you need at least 12 jurors, and then at least one, sometimes more alternate jurors. What voir dire basically looks like is we'll get some information on the jurors beforehand. That'll be used to kind of screen them, and then we'll be asking them questions. The prosecutors ask them questions, we ask them questions. And these can be questions like, how do you feel about certain things, right? Do you believe my client has a presumption of innocence? Do you believe as my client is here today that if they don't testify, are you going to hold that against them? But they can also be more nuanced things. What is this person's, when they think self-defense, what do they mean? When they think self-defense, right? So when different people, they're going to give different answers. And so sometimes an answer that one person gives, you're like, I like that answer, right? Maybe that applies to this case. Versus maybe someone else gives an answer and you're like, ooh, right? That answer, it doesn't fit the facts of this case. Or as an attorney, I don't like that answer, right? Because maybe I'm just like, hey, that answer might suggest that my client, isn't going to be found not guilty. And so you'll ask them questions and you do a jury selection process. And that is something that you're going to do with your client. They get to participate in that. They don't get to ask questions, but they do get to, there was a person today that my client was just like, hey, look, I don't like the way he's been looking at me, right? Well, okay. Hey, we have enough strikes. Let's strike him. So we did that. And then we got into opening statements. Opening statements, it's kind of the roadmap of where the state anticipates the case is going to go, and then where we anticipate the case is going to go. So I think some people kind of confuse, or they don't really know the difference between an opening statement and a closing, right? In an opening statement, you're kind of just saying, this is what we anticipate the evidence will show. Versus a closing statement where I'm going to say, look, you heard the evidence and here's how you should interpret it. So we did our opening statements today, and then we did a number of witnesses. This included the alleged victim in the case, and we got through that. And it can be difficult, especially in self-defense cases, when you do an alleged victim, right? Because I believe that my client acted the way he did out of self-defense. I believe he had to do that. I believe he had a right to do that. And so, in this scenario, my client fired a gun, and I believe he was justified in doing that. But, you have to be careful, because I don't want to paint the victim as too unsympathetic, right? Because at the end of the day, they did get shot. So, you do have to toe that line, but you have to establish, hey, look, what the victim is saying, that's not true. And I think we did a good job of kind of pointing out those flaws today.
All right, so we just finished up presenting evidence. Early this morning, the state presented a few more witnesses. They closed their case in chief, and then we were able to call our witnesses. So we called our client's mom and then our client to the stand.
Yeah, I thought it went pretty well. Obviously we knew that both of those witnesses were going to support us. I thought that client's mom did a good job. She painted the story. She was honest. She told the jury the same thing that she had, told us at depositions. We had our client testify, which is always risky in these situations, but I think he came across really well. He explained what happened to him. He explained why he was in fear for his life. He explained all of the serious injuries that he got from the alleged victim in this case. So I think overall, the testimony went really well for us.
And I think the thing that stood out to me the most is the remorse our client had, even for the guy that's trying to put him in prison. Still to this day, he feels terrible for what transpired that day, which I thought came across very well in front of the jury.
Yeah.
So I'm feeling pretty good going forward.
No, yeah, I'm feeling pretty good. As far as, next step, state's, ended their case, we've ended our case. Next steps is simply closing argument. And then the jury will go and deliberate. There will be some discussion before closing about final jury instructions and what those may or may not include, but we'll get to closing argument. The state will have an opportunity to go. I'll have an opportunity to go, and the state will have what's called rebuttal. But I think we're just really going to focus on, look, at the end of the day, it's not whether or not, as we sit here today, we believe that I think it would have been reasonable for me to do what I did. It is knowing what you do. If you put yourself in shoes and you have everything that happened to you happen to you, you're scared for your life, was it reasonable for him to act in self-defense? And that's really what we're going to focus on, of why he acted the way he acted and why he had to do that, and that was his only choice in those moments. So we just got through the trial, not guilty verdicts. The way that looked is we first did closing. That's something that myself and Zach Richey, we prepped together. We figure out, hey, we have to tie all the evidence together. We have to show the jurors why exactly in this scenario our client fired his gun in self-defense. He had to do it. It was fully reasonable. Thought we did a really good job of that. I thought that we really demonstrated to the jury that, look, this was a split-second thing. And he had to make that decision. And in that moment, it was the correct decision. It was a decision that needed to be made. We showed the jury some case law. We both kind of got involved in that. And I think it came across really well. And then
we waited. So jury took about an hour and a half, 2 hours to deliberate, but we felt pretty confident. One of the big things that the jury would have had to come back and ask is if they wanted to review the video again. But because they didn't come back and ask, we thought that was good for us if the video wasn't in dispute. And really the video was the biggest thing in this trial. And then they came back not guilty.
Yeah, so told our client, hey, you're done, you go home. You never have to think about this case again. And it's an exciting time for him because it's the correct result. He wasn't guilty of doing anything. Bad situation all around, but at the end of the day, this was the correct verdict, and we were confident we were going to reach that, and we're just excited that we did.